Good afternoon. Good afternoon, everyone. I'm Leslie Stein, Director of the Government Law Center at Albany Law School, and I would like to welcome you to the first program of the 2024 Warren M. Anderson series. Just a few brief words before we begin the program. I'd like to start by thanking our series sponsor, George Weissman, in memory of Sharon P. O'Connor, Albany Law School, class of 1979. For those of you who are not familiar with the Government Law Center, our mission is to help state and local governments better serve their communities through nonpartisan legal research and analysis. By bringing together a diverse and inclusive group of lawyers, students, scholars, and community partners, we prepare students for careers as skilled and leading attorneys in public service, advance Albany Law School's unique connection to government, and inform nationwide conversations on government and the law. Today, we have a distinguished and knowledgeable panel of speakers on the important and timely topic of the State of Police Oversight in New York. Our moderator will be Barbara Graves-Polar, Corporation Counsel of the City of Kingston, whose office represents the city and the Police Oversight Board. Last year, the City of Kingston submitted an amicus brief in a case argued in the Court of Appeals in November involving the powers of the Rochester Police Oversight Board. Barbara received her JD from New York University Law School before entering full-time public service. She practiced commercial litigation for several years. She subsequently clerked for judge in the Southern District of New York, has held supervisory positions at Mobilization for Justice and the Legal Aid Society, and has served as an assistant corporation counsel in the New York City Law Department's Appeals Division. Before I turn it over to Barbara, I just want to remind everyone that if you are seeking CLE credit, a code word will be announced during the program. And please remember to return your affidavits and evaluations to Lisa Rivage in order to obtain that credit. The information should be in the invitation you received and with your registration. And now, with no further ado, I will turn the program over to Barbara, who will introduce our panelists and begin the discussion. Thank you.
Good afternoon, everyone. We have so much important material to cover. I think maybe the most efficient way to proceed is just to give each of our panelists a moment or two to tell you what their title is and what purpose or what role they serve in their respective organizations, and then dive right into questions. So I'd like to first start with Nairobi and then go to Tyler and Michael, please.
Thank you, Barbara. Hello, everyone, and thank you for having me on the panel. My name is Nairobi Vives. I am the chair of the Albany Community Police Review Board. We are the oversight agency for the city of Albany, and we were, as you'll hear going forward, instrumental in changing the powers of the board to what they are today. Thank you.
Great.
Hi, everybody, and thanks also for having me on here. My name is Tyler Nims. I'm the chief of the Law Enforcement Misconduct Investigative Office at the Office of the Attorney General.
Hi, everyone. My name is Michael Sazitsky. I'm the Assistant Policy Director at the New York Civil Liberties Union. In our policy department, I help lead our legislative and policy advocacy work on police accountability, and also I'm part of the leadership of a broader coalition of New York-based organizations, Communities United for Police Reform, which obviously does a lot of work on these topics. Thanks so much for having me.
Wonderful. So let's dive right in. And my first question is for Nairobi. I think we are all eager to hear about the legislation that empowers the Albany Community Police Review Board to address allegations of police misconduct. So can you please kick off our discussion by describing the source of your agency's authority, and then maybe describe a little bit more about how your body's work has evolved in recent years?
Sure. Thank you, Barbara, that's a great question. The Albany Community Police Review Board was formed in 2000 in the state that it is now. There were iterations before that in reaction to incidences of police violence in the city of Albany. And in 2021, there was a movement for a change to local law J, which would change the powers of the board from one of a review model that kind of just reviewed what our Internal Affairs Bureau, known as the Office of Professional Standards, their review and investigations of cases, and gave our board the power to investigate on our own, the power to subpoena officers. It gave our board a bigger budget, no less than 1% of the Albany Police Department budget, the power to make recommendations on policy, and a host of other smaller things that help our board work. Prior to that, as I said, we were just a review model and didn't have, as our community had called for, much teeth or much power to really enforce. And with that also, we now have the power to have a say in discipline, which is very important and was a major factor of what our community wanted. So we did look to our community and do a lot of grassroots sort of an effort to see what our community wanted and to work to make our local elected officials make the change to local law J. We had a referendum. There was an overwhelming support. Over 70% of the voters supported the passage of local law J. And we have this form of our board now as a result of that.
And I believe there's a copy of local law J in the materials for today's program, correct?
Yes.
That's great. And one of the follow-up questions I had after looking at those materials was really about some of the training and resources that might be available to the board. I know in the case of Kingston, we've had to at times either engage outside entities to help build capacity within our board, or even sometimes bring in, a consultant who could weigh in on specific criminal law issues or some other issue to make sure that our board was able to investigate in a thorough and fair manner. And so I'm wondering if you can speak for a minute about some of the training or resources that you have brought to the board or that the board has available to it to discharge its duties.
Absolutely. So as I said, part of the changes with local law J was an increase to the board's budget, but as if anyone follows the board and some of the changes that we're calling from the city continuously, it's still, we are having issues with conducting all of the work that we have under our mandate and under our statutory authority. So we have reached out to, while we don't have full staffing like some of the larger boards, like New York City, for example, we do utilize consultants that have worked with other agencies, have a breadth of experience. They provide training to our board members, and we also utilize consultant contract investigators as well to do our independent investigations. Our board, while we are in this transitional phase, is utilizing a sort of hybrid model where our volunteer members review some cases, and those cases that are of major import or higher profile, we vote as a board and have them investigated independently by, we work with TNM LLC or TNM USA out of New York City. So we use a variety of consultants and contract workers to get the job done that we have to do.
That's great. I'd like to turn next to Tyler. Can you talk about, in a similar fashion, the legislation that underlies your agency's power to act, and then give us a rough outline of the scope of your agency's authority to impose discipline in particular cases?
Yeah, so the office that I lead, LEMIO, it's established by Executive Law 75. And this was a part of a package of police reforms that was passed right in the aftermath of the murder of George Floyd and all the protests. So the legislation was passed in June 2020 and then came into effect in 2021. And I think I should underline, the reason why, my colleagues and I have the jobs we have, it's because of the advocacy, it's because of the protests, and because of, frankly, the tragedies that had occurred, not just George Floyd's death, but many others, leading up to an emphasis on on an attempt to find new ways of police oversight and accountability. So, I think we keep that in mind as we do our jobs. So just taking a little bit of a step back, Lemio is not the only unit at the AG's office that works on police oversight or police accountability. On our criminal side, we have the Office of Special Investigation, which is charged by statute with investigating and prosecuting where warranted deaths caused by law enforcement officers, both police and then also in prisons and jails. And then on the civil side, in the Social Justice Division, which is where Lemio is housed, we also have the Civil Rights Bureau, which works on investigations of patterns of police misconduct, sometimes in conjunction with the unit that I lead. So we're a relatively new unit here at the AG's office, part of a trend towards increased emphasis on police oversight, but also on state level oversight. That's really, I think, gathered steam over the past decade, and especially after 2016. Prior to 2016, there was a lot of focus on what can the federal government do. After 2016, with the election of former President Trump, and there was an increased effort in some states to look at what can the state AG's office do in terms of police accountability. So now focusing back on Lemio, we have jurisdiction over local law enforcement agencies in New York. So there's approximately 600 or so. We don't have coverage over the state police or the MTA police or the state university police agencies. And under the statute, we can investigate allegations of misconduct. We can recommend reforms and disciplinary action. We can recommend legislation. We can make referrals to district attorneys for criminal prosecution. And then where there's a sufficient pattern of legal violations that we find, we can use the Office of the Attorney General's parens patriae jurisdiction to bring legal claims against a police department or municipality, and in effect stepping into the shoes of members of the public who have those claims. And that's what our civil rights unit and others have done with respect to NYPD. There was a large litigation relating to their response to the protests in the summer of 2020. You may have seen some press, a case recently settled with a negotiated resolution. Okay, so I'm going on and on here, but I'll just get to your specific question. We have a very strong suite of investigative powers, and we can make recommendations, make public reports, but what we don't have the ability to directly discipline a police officer. So I think that's something I'm sure that what we could talk about all the different laws and kind of cultural issues that govern police discipline. But we have the ability, we have a number of powers, but not that particular power to discipline. And I guess I'll just make one more point. We're part of a broader ecosystem of police accountability and police oversight, and that includes the police, internal affairs units and the police agencies themselves. It includes civilian oversight, like the agency that Nairobi leads, and involves advocates and activists and community members like Michael and like Michael's folks at Night Clue and many others, state and local elected officials, district attorneys. You get the picture. But what I'm trying to say is that in our unit, as we think about what we do here, we don't want to duplicate or displace anybody else that's in this ecosystem. We want to find where there are gaps and try to fill those gaps, and we want to try to find ways that we can operate to kind of strengthen the whole ecosystem.
And before I bring Michael's perspective into this discussion, I just want to ask one follow-up question for you, Nairobi, and also Tyler. Not to put you on the spot because you're doing so much work, but is there one aspect of either your complaint submission procedure or investigation procedure or outreach that you think has been most successful in starting to establish real public trust in your agencies?
Sure, I can take the first stab at that. I talked a lot about the changes to the board, and previously community members could only make complaints directly to APD, which would result in a lot of complaints to our board. We've recently made changes to allow in the past community partners to receive complaints, which has been very helpful and increased trust there. And then for our board directly, we can take complaints through our web form system. We can take complaints anonymous through board members. We, as the board members in the local law J, we can file a complaint on behalf of, an incident that we hear of. So that taking that direct interaction between a community member and a police officer out of the requirement for there to be a community complaint has helped a lot with trust and has helped a lot with the number of complaints that we are seeing.
Tyler, I don't know if you have anything to add.
I think from my perspective, our unit is still very new. We're still figuring out a lot of how to deal with this new and unique legislation that creates us. I think the more public we can be, that's kind of step one in trying to establish a sense of trust and legitimacy. I think more engagement and communication we can have both with our covered agencies and with the public, the better. Those are just that's easy to say and hard to do given the scope of the task and the complications and challenges in the field.
And so, as promised, I'm turning to Michael. Michael, the NICLU report that's in the materials for today's program is just full of important, sometimes disconcerting, but still important information, a lot of data that you were able to gather. 2 points jumped out at me that I'd like to start focusing on. One was that African-American uniformed officers were 33 times more likely to receive serious discipline than white officers. And the other was that 93% of the children identified as injured parties in complaints were children of color. So I'm wondering if you could start by speaking to those findings and then, any other police oversight realities that you think our audience should understand.
Sure. And I'll provide a bit of context for the report as well. So we at the NYCLU had been working with our partners for years to repeal a law that was in place that had blocked access to police discipline and misconduct records, Civil Rights Law Section 50A. This was a provision that made it really impossible to gather data, to gather actual cases of what is happening once a complaint gets filed with a police agency or an oversight agency. Is it investigated? Is it something that results in any kind of real accountability or consequence for the officer found to have engaged in misconduct? And that was a law that was on the books since the 70s, was repealed by the state legislature in June of 2020, following the nationwide uprisings and protests following the murder of George Floyd. And once that law was repealed and we had access to those underlying discipline records, we started to gather data from the CCRB, from the NYPD, from police departments around the state to see, to complete the picture of what actually happens, how many complaints are being filed, are they being investigated, who's the target of those complaints, who's the injured party in those complaints. And what we found was, maybe not surprising based on what we have heard from community partners, that we expected to see a lot of disparities, but the real magnitude of disparities was alarming. We wanted to get a sense of what discipline looked like within the NYPD, and the best way to do that in our report was to look at what was happening within the Civilian Complaint Review Board, which in New York City is the outside entity that has oversight of NYPD misconduct complaints from members of the public. And we analyzed more than 20 years of data starting in January 2000, and looked at what happened in the 180,000 complaints that had been filed in that time frame. And it reflected the kind of disparities that we had, again, heard from partners that reflected what they had been witnessing in their communities, especially the data point on young people of color that were disproportionately targeted by police. It reflects the existing realities of how the NYPD has operated in communities, that they have long had a very aggressive approach to enforcing low-level broken windows offenses, stop and frisk abuses. It reflected all of the same patterns that we had seen in the disproportionate targeting of young people of color. It harkened back to the era at the height of stop and frisk in New York City, when in, I believe it was 2011, there were more stops of young Black men in New York City than there were young Black men actually living in New York City. So the disparities there really reflected the pattern of some of the really biased and racist approaches that we had seen, perpetuated by the NYPD. And we also wanted to examine, to the point about, Black officers being 33% more likely to face serious discipline. We also wanted to see, are these systems, working internally within these agencies? Is there, concerns about corruption or unfair treatment within police departments? How do these systems internally have checks to make sure that they are themselves really committed to holding officers accountable and to not replicating some of the disparities that we see out in communities? So it was really eye-opening into just how massive the system was, how many flaws there are, and just what the harmful effects were. Lots of other findings in those reports as well, which I'm happy to dive into, including some of the, what it speaks to in terms of actual outcomes for discipline for officers, which was, by and large, the NYPD ignores recommendations from the CCRB.
Barbara, you're muted.
Sorry, I think our audience would like to hear a little bit from you and from Nairobi, but before we go to that, I believe we have to give the CLE code word. So I want to give a pause here for our partners at the Government Law Center to provide that.
Yes, thank you. The CLE code word, for those of you attorneys looking for continuing legal education credit, that code word is EO203. So the letter E and the letter O, numbers 203. Thank you.
So Michael, you were starting to, I think, go more into a discussion of the disparate outcomes in police discipline. And I'm wondering if you can share one or two thoughts on that before I just turn to Nairobi and ask if there's any other insight from her work that she would like our audience to understand.
Sure. And so, when we looked at some of the patterns of what happened with these misconduct complaints as they were being, processed through the agencies, we found that it was really difficult for, it's difficult in general for any oversight agency to really get to a meaningful consequence for officers. And that was no less true of the CCRB and the data that we reviewed. So in those 20 years of records that we had looked through, only about 2% of the 180,000 complaints in that time frame resulted in discipline for an officer. And in less than 1% of those complaints was it serious discipline. So something like, a loss of vacation days, a suspension, probation, or termination of the officer. And we also found that, when the CCRB, which investigates and can make recommendations to the NYPD, and more serious cases can prosecute cases in the NYPD's trial room. At the end of the day, they're still just making a recommendation to the NYPD as to what to do and what discipline to impose in those cases. And we found that in that 20-year period, where the CCRB had actually substantiated an allegation of misconduct and recommended discipline to the NYPD overrode the CCRB's recommendations and imposed either a lesser degree of discipline or no discipline at all in 74% of those substantiated cases. So this is still very much an issue where the agency is doing what it can to investigate and try to recommend meaningful consequences for officers, but they're operating in a system where the NYPD ultimately has all of the power and calls all of the shots. So the deck is really stacked against any agency that's trying to get real accountability when they are faced with a power structure where they can, ultimately just at the end of the day, make a recommendation that is reliant on the folks in power actually wanting to do something with it and actually having a real commitment to accountability.
Nairobi, do you have a few additional thoughts to share on that?
I echo what Michael said. Like, while Albany doesn't have the same statistics, what we've learned when we talk to other oversight agencies, when we look at our own experience, is that exactly the power that Michael talks about being up against when you are investigating and making recommendations for discipline. It is just an uphill battle. So our board, while we have the authority to recommend discipline, we've gone through a discipline matrix process with the Albany Police Department, with community members. The NYCLU has helped in that as well, and with our board members, so that when we do get to that point, that we're trying to be proactive about some of the difficulties that we know exist. So we are coming to the end of that process, and hopefully we'll have a finalized version of that matrix. But we've also taken other steps to make sure that when there are differences from our recommendations in the future, it's written into local law J that, you know, the chief needs to let us know why that would be. We also have another layer now in Albany with a public safety commissioner, and we've, you know, advocated and asked our common council to make changes to make sure that when there is a change ultimately at that level, when and if, that they need to reference the recommendations by the CPRB. And while you can't control everything, but giving that sort of transparency to our community to say that, you know, there needs to be acknowledgement at every step of the way. If there are changes, we need to go back to that grassroots coalition that we had to say that we need to, you know, recognize that these things are happening and make changes in the future if that's the case. But I think Michael's words are what my board and other boards feel and will feel as we go further into the discipline process.
This seems like a great moment in our discussion to start to turn to the Rochester Locust Club case that Judge Stein mentioned at the outset. And before I ask Tyler to sort of kick off our assessment or discussion of that case, I just wanted to explain why Kingston weighed in the first place. I mean, we're a small city, very small city, but in 1999, we revised our municipal charter to create a 5-member police commission that's chaired by our mayor and has engaged community members who we see reflect our city's diversity really in all of its forms. And then in 2020, like a lot of municipalities, our common council stepped up to really think about bringing that commission more into the 21st century and to respond to, you know, changing needs and demographics, and really outcry from the community to provide new guidelines for the mayor to take into his chairing of that commission and to guide its work. And so that system of oversight isn't perfect, but it's one that we're able to fine tune. And so we were concerned about the core question in the Rochester case about that local capacity to fine tune an issue that is affecting our communities on the ground. And so that's why, you know, even though we're quite different in terms of size and structure from Rochester, it was important to us to participate in some form, or at least to have our voice heard on the issues. So Tyler, can you speak with perhaps a bit more granularity about that case? And in particular, the report that's included in the materials at pages 15 and 16 offers some concrete recommendations about next steps in response to the decision.
Yeah, and I smile because it's a very complicated case and a very complicated set of case law that governs when a municipality can control its own discipline process versus when that process has to be part of collective bargaining. And that complicated case law and that very complicated test, which requires the courts to look back into municipal legislation, you know, going some cases far back as 100 years to determine what the intention of the municipality was at that point with respect to collective bargaining, when these issues weren't even, you know, nobody was thinking about these issues or even knew that this test exists. Long story short, that complicated test, I think, is probably part of the challenge or problem here. So in this particular case, as you explained, I mean, this was essentially in Rochester, the voters there was a referendum. The voters had voted to create something called the Police Accountability Board. One of the things the powers that they endowed the board with was the power to directly discipline officers. And that was challenged by the Locust Club, which is the local union. And essentially they argued that based on the way that Rochester's municipal law was structured, discipline was required to be by state law. Rochester's municipal law meant that under state law, discipline had to be handled by handled through the collective bargaining process. In other words, the voters of the city of Rochester could not change discipline. The only way to do that would be to negotiate a different contract with the police department. That, was litigated all the way up to the Court of Appeals. It's a kind of a question that's come up many times or a few times over the past couple decades with respect to other places, New York City, I want to say Schenectady, Wallkill, probably some others. But in those cases, the Court of Appeals had conducted this historical test and decided that the agency, that the city possessed the disciplinary power, not that, and it didn't have to be part of collective bargaining. In this most recent decision, looking at Rochester's unique history, they decided, no, it did have to be part of the collective bargaining process in Rochester, no matter what the voters of Rochester had concluded. And, it's a kind of an interesting result. And it was a divided Court of Appeals, 4-3. Both sides pointed, both the dissent and the majority pointed to the state legislature and said the legislature can clear this up. And I think, from my own point of view, and I think from the point of view of my agency, I think it's better for municipalities and people who live there to be able to make decisions about the kind of oversight that they want and need. And so I think, if the legislature would take that up, I think it'd be a helpful for police oversight and accountability across the state. And I'll just say one more thing. I mean, we're talking about the state, right? There's, we've got the New York City Police Department that Michael was talking about. It's got 30 to 40,000 officers, employees. There's the Albany Police Department, it's probably somewhere around 300 or so. Nairobi, don't check me too hard. But we've got 600 agencies and they vary completely. There are some that don't even have a single full-time police officer. So, given that context, I think the more that the localities can help determine what they need out of their police management, the better.
Mm-hmm. I too was thinking about going next to Nairobi on this issue because the amicus brief that was submitted on behalf of your agency urged the Court of Appeals to, and I'm just going to quote right from it, expressly hold that the state policy favoring local control over police discipline is strong enough such that municipalities are always entitled to entrust disciplinary determinations to decision makers that represent the community. So what are your thoughts about this ruling based on all that you described about your municipality and the size of your force and just local conditions that Tyler alluded to?
I echo what Tyler had to say, and Albany, our corporation counsel did not submit an amicus brief, and in this case, we used pro bono counsel to do so, and we did so because it was very important for that very point that you just described, that local control in the state of New York has been a public policy that has been strongly supported up until to this point, and our amicus brief included, a host of just history of that very thing, and that it is a codependent relationship between the police and the community. And if the community does not feel that trust and accountability and the legitimacy of its police department, then it can't work. And including the community in ways through oversight agencies like the one in Albany, like the commission that you talked about, that is a way to get that trust, to build back that relationship. And exactly what our amicus brief said, like Tyler said, if this is something that the legislature could take up, it would be great, because it would help a lot of agencies like mine who are fighting this uphill battle, and communities that are crying out to have a say over, what their officers do in their community. They want to feel safe and protected. They don't want there to be disparity between certain neighborhoods, and that is key. If the community is not involved, then that can't happen. There's no trust, there's no accountability, and that codependent relationship, everything fails.
Tyler, I see, or I'm sorry, Michael, I see you nodding. And so I want to turn to you to weigh in and actually ask you a related question. We haven't really talked about the role of the New York State Public Employees Relations Board, or PERB, at all. And so I'm wondering if you have any thoughts either on PERB's role, or, how any of that factors into your post-Rochester Locust Club sort of advocacy.
Sure. So agree with the points that Tyler and I were making. This is an issue where the state of, police discipline and the ability to control it across the state, it's a patchwork now because of some of these rulings. So, you have places like New York City where the Court of Appeals had said, because they had a local law in place that already committed police discipline to the authority of the police commissioner before the Taylor law, before the civil service law came into effect, New York City gets to keep that, but Rochester doesn't because they made some changes to it. It's a mix of some places that are able to more directly control discipline through the authority of a local official, and others where it's subject to whatever a police union is able to win in their contracts, which then invites in the ability for arbitrators who are chosen by police union officials to make the final call. It brings in the ability to bring more complaints to PERB, to have the Public Employee Relations Board weigh in on some of these disputes in the meaning of particular terms in contracts, or to look at what is happening in those cases. So it's inviting in a lot of folks who are pretty disconnected from the ultimate issues that are impacting communities when someone experiences misconduct at the hands of an officer and wants to actually see some kind of meaningful discipline, meaningful accountability imposed. And that's why it's the legislature can certainly step in here, and I think it's something where we want to see some kind of resolution here, because even in and it's even in places like New York City, where right now there is no bargaining over discipline, where it's all handled at the NYPD, and it's not something that's going to go into arbitration, it's not something that's going to go before PERB. There's still this question of, like, what if New York City wants to change its practices? Are they going to invite in future litigation into this? Are they going to invite the opportunity for collective bargaining to be reintroduced into the mix? And even with the existing system, we have a system where we're not inviting in outside arbitrators or dealing with contract negotiations over disciplinary proceedings here, but we still have a process that is entirely controlled by the police commissioner. And is that actually a good and accountable system? To the example from Rochester, the Rochester Common Council had gone through a process of identifying not just like what this new police accountability board was going to look like, but who are the actual communities that are going to be represented on that board? What are the constituencies that we want to have in place there? And how can we make sure that the decisions that are being made there are reflective of community needs in a way that was actually speaking to the lived experiences of the people in Rochester who experience police abuse. That is something where the lack of any kind of real ability of a lot of these localities now to think more creatively, to design more accountable systems, really makes it all the more imperative that we now have some kind of action taken by the legislature to say, here's what a locality can do to carve out an actual model of police discipline that is putting power more directly in the hands of those who experience harms at the hands of a police officer. And here's a way that we can do it without getting so far removed from communities that we're letting police union contract negotiations, at which police unions are fairly well resourced and have a lot of ability to use their muscle to push for really highly protective provisions that are often at direct odds with what communities need and expect when there are misconduct complaints that go in and get investigated. So it's a complicated, tangled web, but it is one that is really incumbent on the legislature to start thinking about how to untangle that and how to more directly empower communities to design really effective and accountable models.
And I'd like to focus on one more investigation-related issue that somewhat ties into some of the points you just made, Michael, before we then turn directly to 50A and kind of post-repeal concerns. Tyler, I was really struck by a point in one of the footnotes of the report from your office. It's in the materials. In footnote 14, it identifies a separate civil service law provision that in some respects might limit even your office's ability to respond to misconduct. Can you say a few words about that?
Yeah, and you flagged this for me ahead of time, which I appreciate, because otherwise I wouldn't have been able to pull out one footnote from our report. But yeah, civil service law essentially imposes an 18-month statute of limitations for most disciplinary actions against a public employee, including police officers. There are some exceptions, or there's an exception where the conduct is criminal in nature, which can extend that statute of limitations. But that's a challenge. I think both for agencies. Often their internal affairs are understaffed or overwhelmed. Sometimes the investigations of tough cases or the more serious cases take too long, or are reported too late. And then, so that's an issue for the agencies. And then for our office, one of the unique provisions of Executive Law 75 is that agencies are required to refer to us officers who have 5 or more complaints, and then we're required to determine if there's a pattern of misconduct on behalf of that officer. And often, I say 5 complaints, or 5 or more complaints within 2 years. So often we get referred complaints or issues that are already nearing this statute of limitations. And so that's a challenge. It's a particular challenge with respect to that statute. I want to make one just broader point, though, quickly. I mean, we're talking a lot about discipline and accountability here, but that's not the only tool for trying to get better conduct or better relationships between officers or agencies in their communities. I mean, you also have kind of the water that everybody's swimming in. I mean, what are the policies that are in place? What kind of training is occurring? What's the culture of the agency, in terms of the officers and the management? What's the tone at the top like? And that really varies, across agencies in many different ways. And then what are we asking the officers to do? Are they being put in situations where misconduct can occur? Are they, how are they being deployed? What kinds of things are they, or we as a society, asking officers to do? So there's a lot of things about discipline that can be changed, but I just want to make the point that that's not the be all and end all of what officers are doing on the street in terms of when they're interacting with people. There's a lot of other things that feed into this picture that I think, really deserve a lot of attention. In some ways, if you're talking about accountability, it's too late, right? Like it's, you want to be doing the things beforehand that stop the things from happening. And maybe deterrence is part of that, but it's just one part of many different things.
That's a really great, I was going to say point, but it's actually a set of points that you made that could actually fill its own hour-long CLE. And I am also mindful of our time. And so, Michael, I am mindful of the fact that I am about to ask you to, in say 5 minutes, tell us what's going on with post 50A repeal advocacy from your office, and maybe the best way, or for your agency. And I guess the best thing to do is to maybe share a couple of thoughts about the 2 decisions, the 4th Department decisions that are in the materials, and then sort of project forward about the kind of work you're doing following them.
Sure, and try to keep it super brief. So as I had mentioned before, in 2020, the state legislature repealed Section 50A, and that meant that now all law enforcement disciplinary records, which were previously secret, are now presumptively available to the public to request via FOIL, the Freedom of Information Law. There were a number of other changes that were made to FOIL at the time to clarify that, to define the scope of what a law enforcement disciplinary record is, to carve out specific types of information that would not be released. So things like officer home addresses, personal cell phone number, sensitive medical information, the types of things that were not really of actual public concern. But it was a very clear and full repeal of 50A, making sure that all of these records are now presumptively available. Naturally, that led to a lot of litigation as those FOIL requests started to go in. And we saw throughout the state a number of police departments, police unions intervening and weighing in, trying to claw back the repeal and basically carve out entire categories of records that they were going to try to fit into various FOIL exemptions. So we started to see court cases that went through claiming that law enforcement agencies weren't required to disclose records of discipline that existed prior to the June 2020 repeal of 50A. We saw a lot of arguments coming up that categorically police departments were refusing to turn over unsubstantiated complaints, so complaints that didn't actually result in a finding that the officer had committed wrongdoing or that any discipline was imposed. We saw arguments about police union contract confidentiality provisions, somehow blocking public access to records. So a lot of back and forth, and at the start, some mixed decisions about what exactly was subject to public disclosure following the repeal of 50A. Recently, the Fourth Department issued rulings coming out of Syracuse and Rochester that stemmed from FOIL requests that the NYCLU had submitted to those police departments seeking access to discipline records from those agencies. And the Fourth Department ruled that 50A's repeal was, as we said, comprehensive, that it applied to, it applies retroactively. You can't say that just because a record existed prior to the repeal of 50A, you get to keep it secret. No, the court said that you have to actually release those going forward. There is no blanket privacy exemption that allows for categorical withholding of unsubstantiated complaint records. Agencies have to conduct individualized reviews, and to the extent that they can release anything that is not constituting an unwarranted invasion of privacy, they can redact and release the remaining portion of the record, and just made really clear that this was something that was a sea change in how 50A related materials would be subject to public review going forward. That said, it's now going before the Court of Appeals, and that I don't think has been calendared yet, but I think we're looking at maybe earliest being May that it could be argued. But we expect kind of like full resolution of the issue then, which is not to say that all of the issues are going to be resolved, and there's still opportunity for legislative action here. One of the key issues that is still inherent in these rulings is, a dispute over whether or not you need to release officer names in these unsubstantiated complaint records, which from our perspective, and I think from the perspective of the legislature, it was really clear to lawmakers when they passed a repeal of 50A that they wanted to have access to those records because unsubstantiated complaint patterns, if there's an officer racking up 10, 15 unsubstantiated complaints for the same category of misconduct and a police agency that is just ignoring those complaints, not imposing discipline, that tells you something about the operations of these police departments and whether they're actually operating effectively and in the public interest. So I think that's going to be a major fight going forward is, the scope of whether or not we have access to that level of information. And it's something that the legislature can also clarify. There's been a bill that's been introduced now for a couple of years by Senator Jamal Bailey and Assemblymember Jessica Gonzalez Rojas that would clarify the FOIL statute and make clear that all of these records are available, cannot be subject to continued withholding, don't fit within the FOIL exemptions, and really preserve the legislature's victory in the 2020 repeal of 50A. So we'll see how the Court of Appeals ruling comes down, but in the meantime, there is that opportunity for legislative action to prevent the need for further litigation on this front.
It feels like FOIL compliance in a changing landscape and the particular burdens that small municipalities have in complying with FOIL could fill its own. Those issues could fill multiple CLEs. But in the time that we have remaining today, I'd like to just offer our panelists one final opportunity to share thoughts on how concerned advocates and other community stakeholders can support your efforts to make police accountability fairer and more effective. Anyone can kick it off.
Barbara, it's a great question. For the Albany Community Police Review Board, continued support from just our community to continue to, if something goes wrong, make a complaint, volunteer, tune into our meetings. But the bigger push for legislative change on a local level, state level, the support in that, as we talked about today, and like you said, there are so many things that come up that could be their own discussions. All of that would be so helpful for many of boards like mine. I talked about some of the issues, but there's even smaller boards that have less resources, less help, and could really use the outside support because it is a really important endeavor. And most of the time it is just volunteers doing this work. So I think that would be the most helpful from a oversight agency perspective.
Michael or Tyler, do you have any other thoughts?
I'll say there are a number of efforts that the NYCLU is involved in, which we welcome folks to take action. We have a number of priorities that we're supporting at the state level, at local level here in New York City, and in localities around the state. Many of which are on our website, nyclu.org. I'll just plug a few. Folks can get involved in some of the campaigns with the bill that I just mentioned to clarify the repeal of 50A. We're also working to some of the points that come up about what oversight can look like in other capacities. We're really interested in trying to reduce the actual number of police civilian interactions to begin with that lead to misconduct occurring and to a complaint being filed in the first place. So that also involves getting police out of circumstances where, frankly, they have no business being our default responders. So we're supporting legislation at the state level called Daniel's Law, for example, that would create a statewide system for mental health response that is not police involved, that is sending out peers, mental health and health professionals to actually respond to people in mental health crises, substance use crises. Since that's an area where we often see escalation, where we often see complaints of misconduct and excessive force, and it's an area where we can drive down the amount of abuse that is occurring by actually responding to community-based problems with solutions that are actually tailored to them. So I encourage folks to take a look at some of the information on our website for other campaigns to get involved in, but that's what I would offer up on that front.
Yeah, I don't have too much more to add other than what Nairobi and Michael have said, but I do think, the more, for those who are less directly impacted by this kind of thing, the more informed and the more, active you are in terms of understanding what's going on with the agency that polices the place you live, or the advocacy groups, or the other folks who are doing work in the areas that you live, supporting your local press, which is the ones that usually cover these kind of issues. And then for those who are, impacted, I think people feel very, cynical and probably rightly so about government, but I do think we raise these issues with the agency themselves. We could raise them with our office, not everything's gonna be addressed, but I think the more information that gets into the system, the more sense of what's going on is out there, and the more that the sort of folks who are in this field can try to address those issues.
We probably have time for one or two questions, but before we open the discussion for Q&A, I just want to thank our incredible panelists and Albany Law School State and Local Government Law Center for organizing this program. So, Chal, I will be watching the chat, or if you want to share one of the questions for our panelists to answer before we close.
Sure, I can share a couple. So one major question is, I think we've touched on it a bit, but a question is about, what is being done in New York to preserve some of the powers that these boards have accomplished. And I think we've talked about it a little bit, but in the context of seeing what other states look like, I guess what else is happening that we could speak to that folks might think about?
So just to make sure that we're all understanding the question, is that, what in non-litigation efforts are underway to help strengthen existing police oversight boards? Is that
That is correct, yes.
Okay.
Maybe in addition to anything that we've talked about so far.
So I don't know, I see a little bit of a nod from Tyler, and I am wondering if maybe some of the discussion about community outreach and capacity building that was noted in your office's report, if maybe you could speak to that, because it seems to address some of the issues that the questioner, that the individual who posed the question might want to learn about.
Yeah, I think it's a good question, but it's a very broad question, in terms of what's going on. I think, New York versus the nation. I saw some questions in the Q&A. Maybe this original question goes to that. In terms, in New York, we've had some progress in terms of state laws and active, actions at the local level towards more accountability. I think in other places with different political dynamics, you see the trend going in the opposite direction. So I think, I mean, I think that's a trend that's concerning, and the more folks that are, engaged and interested in these issues that are paying attention, the better, whether it's in New York or anywhere else. In terms of outreach from our office, I mean, outreach it's fundamental, I think, for the work that we all do, and engagement, in terms of trying to build relationships that helps us be more effective, perceived as more fair, perceived as more legitimate. But it's easy to talk about outreach, and it's hard to actually do it, especially in a statewide level. But I'm sure Nairobi and your colleagues face challenges there too. Try to hear from the people that you need to hear from. It's hard in this field. I don't know if I answered your question, Barbara, or the question from the public, but those are some of the things that sparked in my mind.
It's a very broad question, and one
Right.
again that has a lot of different angles to address. I'm wondering, Charles, should we try to maybe have one additional question before we wrap up the program?
Yes, and I think this is going to be connected to that outreach conversation. There's a specific question about how these agencies, police oversight agencies, handle the issue of police interactions with people with disabilities, ranging from people with mental health issues, and I would add trauma histories, and also people with intellectual or physical disabilities, or if you've seen that. I think Nairobi, what I do know about the
Shell, I
Albany
was gonna
board. Sure.
say, I froze, so I missed the first part of that question. I don't know if
Oh, sure.
it wasn't directed to me.
Yeah, yes, and all kind of each of you. What are your agencies seeing, or what are some of your efforts related to interactions between police officers and people with disabilities, mental health issues or intellectual or physical disabilities, and I would add maybe trauma histories. I think this might speak to some of the outreach, but maybe also training.
Absolutely. We've had higher profile cases dealing with people suffering with mental health issues, and we're always working towards training and increased efforts around de-escalation, those sorts of things. When Michael is talking about removing police from situations where they're not supposed to be, or they're not the best to respond to them, we're supporting of that. But in our review, we are always questioning, whether there was a proper assessment of the person's mental health status. I know our vice chair, Dr. Vanelia Hardin, who works in this field, is always, looking towards that. So it comes up a lot, and we are always trying to be as proactive as we can to address it.
I would just add in the case of Kingston, this or at least certain of these issues were addressed outside of the police commission itself. For example, the creation of the mobile mental health response unit. That goes directly to one of the issues that Michael was talking about, looking at ways to avoid certain types of encounters that are kind of at higher risk of involving violent encounters between individuals and experiencing acute mental health crises and uniformed officers. And so again, that's not something that necessarily is a commission effort. It was a city effort in response to a perceived need. So we are just a minute over our time, so we probably can't take any more questions, but certainly this is the beginning of a very important conversation that I am so